I have the distinct honor of moderating and commenting on the papers from our second panel of the day, Civil Law Asia. We will proceed in the order that they appear, and so without further ado, let me turn it over to Stefanos.
All right, good afternoon, everyone. First of all, I'd like again to extend my gratitude to PJ for bringing us together and inviting me here, so I'll be forever grateful for his generosity. So today, I'm going to discuss about the judiciary review of electoral process in Indonesia. So I will divide my presentation in two sections. The first part, I will explain about the Indonesian Constitutional Court itself, so history, and then about the court structure, and then the second part I will move to the some important cases that were decided by the court in the last 10 years or so. This is important for me to start with the structure first, because I just want to explain about how this is quite complex also, not complex like in the case of Malaysia or India, but the complex in the sense that Indonesia itself it's become more complex because there's many different factors. I will explain it later. So the Constitutional Court was established in 2003. Backtrack a little bit. In 1999, that's the first free general election in Indonesia after the fall of military government. So 4 years later, the court was established. And it was established right before the 2004 general election. So this is a kind of background for you to understand. So in 1999, they only have the first free elections for the parliamentary, but there's no direct presidential election. Direct presidential election didn't take place until 2004. So it was just a year before the court was established. So in 2003, the court was established with kind of limited authority, because the politician who designed the court, initially they designed this court like a joke in some way, and later on it's turned to be serious. They first they created this court as a court of impeachment to review the procedure, impeachment procedures against the president, but then they added some jurisdiction to the court, including the statutory review. So the court here was equipped with the authority to conduct judicial review, but limited only to review statutory regulations. The court has no authority to review any ordinances or administrative actions. All those powers were reserved to the All Supreme Court. So this is kind of the different jurisdictions. So the the Constitutional Court jurisdiction is pretty limited. But they open the standing, the law says that to any citizen who can file any complaints to the court, not in the sense of constitutional complaint like in Germany or in South Korea, but more things that private citizens can file or can challenge the statute before the court. In the sense they can ask the court to interpret statute, not to bring their own interests, although they can frame it that way, which is I will discuss later. So it's quite complex and unique. This is kind of, I think, come out with the lack of ignorance for the politician who designed the court itself. And later on, I think they have to they deal with this issue. The court itself is composed of 9 justices. I think that 3 appointed by the president, and 3 appointed by the parliament, and 3 appointed by the Supreme Court. So today, I think that as we can see that, especially I think that last year in 2014, that people see that the court had to deal with the constitutional, the election result, which is the presidential election between the President-elect Joko Widodo, who now the current president, and his rival General Prabowo Subianto. Many people give praise to the court for each decisions at the time to certify the general election result. But I'm not going to deal with this kind of issue. Although the court has jurisdiction to review the result of general elections, this is mostly simply to review the result itself. mostly to calculate the number and stuff like that. The court did not really deal with the process itself. More the process, I think, being decided in the statutory level. So that's why I'm not going to focus on the judicial review of the result of general elections, but rather on the statutory, interpretations, which is, I think, involved with election issue. And I think that in the last 10 years or so, the Indonesian Constitutional Court has come, I think, come out with a kind of a, I call it quasi-weak form review. There's 2 points here. So first, the court mostly issue an advisory remedy. The court can declare the law unconstitutional, but this decision will not be able to, give remedy to the claimant's injury. So the only advisory remedy. Second, the court may refuse to declare statute unconstitutional, but rather court asks the government to interpret statute in a certain way or give some directive to government to interpret statute. They call it the technique is a conditionally constitutional decision. I'll explain it later. So this is kind of background. So let now, I think, I'm going to move to several cases, important cases decided by the court in the last 10 years or so. The first case was the Communist Party case. This was decided in the early days of the court. Just a background. So since the failed coup attempt by the Communist Party in 1965, the military government at the time that banned any member of Communist Party or former member of Communist Party to run for elections as legislator, or they didn't have a voting right either. It's happened for more than 30 years, and it continued after the fall of military government. So in 2003, some former member of Communist Party wanted to run for election, in legislative elections, but General Election Commission say no, you still have no right to be elected. So then when they went to Constitutional Court, here what happened is that they did not, ask the court to review the General Election Commission decision because the court has no authority to do so. What they did is they asked the court to interpret the statute. And the court held that individual members of Communist Party and any of its affiliates should be treated equally as citizens without any discrimination. So it seems now here the court issue a favorable decisions and people assume that they will gain their rights and they will be able to run and be elected. But the court say, no, this decision has no effect immediately because they filed a case in 2003 anticipating that 2004 election. But what the court say that this decision will only be implemented for 2009 general elections, which was 5 years from now, so not for the coming elections. And the court just said that one of the reasons is that because these decisions can be only applied prospectively, retroactively. But also other reasons, as I explained, is because I think that the nature of the judicial review in Indonesia is not reviewing the concrete case. It's not dealing with the election commission decision, but rather that to interpret statute in abstract way. The second case, I think that this is decided again, I think that around the same time. This case is a political crime case. This involves a political dissident named Budiman Sujatmiko. He was the chairman of People's Democratic Party. So this is the new, not the old Communist Party, but the new one. And they were in the forefront of the struggles against military dictatorships. And he was put in prisons and has to serve 13 years imprisonment. He was released after the fall of military governments and tried to go back to politics. What he did, he had to challenge the provision in the presidential election law. The law provided that a presidential candidate shall not be previously convicted of a crime of 5 years imprisonment or more. So yeah, there's no way for him, to run as a candidate. And he challenged the law. The court held that the law is lawful. He said the law is constitutional as long as prohibition does not include political crime or minor offenses. So the court here defined the political crime as political expression or political view which was contrary to the few of the previous regime. So here the court invented a technique, they call it conditionally constitutional. Again, here it seems that the court just give abstract, advisory opinion, advisory remedy, and did not really means that bring any change to the case, because other reasons also that there's no way that this man he can run for president. I will explain later why, because the threshold is too high for a small party like his party to run to nominate somebody as the presidential candidate. I will come back to that later. So this is the things that two important cases in the first few years of the court. This is at the time when the court, under the leadership of the first Chief Justice, Jim Lee Ashidiki. As I said earlier, that nominating powers is divided between three branches of government. So technically, the president has no power to remove the Chief Justice or nominate the Chief Justice, because Chief Justice shall be elected internally by the Supreme Constitutional Court justices. But the problem is that the politicians design the law in the sense that Chief Justice has to be re-elected every 3 years internally. So like Chief Justice Jim Lee Ashidiki, he has to run for re-election after 3 years internally. And for the president who do not like a Chief Justice, he can set a plot, or like the then President Susilo Bambang Yudhoyono, he has power to nominate 3 justices for the Constitutional Court, and his party control majority in the parliament. So his political party in the parliament can nominate 2 other candidates. He controls 5 basically, and Chief Justice simply Ashidiki was voted out in the second term. So there's a new Chief Justice. So in the first general election cycle, this is the first time for Indonesia, I think second time for them to deal with the direct presidential elections and the new election systems. They didn't see so many complex issues, but coming to 2008, 2009, they began to see many more complex cases they had to deal with in the general elections issue. This is the time when the second Chief Justice already in charge. This is Chief Justice Mahfud. I will take the 2 important cases from his term. The first case, this involved a political dissident, again, his name Muhammad Soleh. He was also a former member of PRD, put in prison also during military dictatorships, but later on, I think after he was released, he switched side and joined the more prominent party, Indonesian Democratic Party of Struggle. Well, he made a mistake because he never found home in his new political parties because people never really trusted him. So in 2009 general elections, that he was put in ranking 7 in the party list, The law says that to be elected, a candidate must achieve at least 30% of the voting division number. So voting division number is calculated by the total valid vote of political parties in one district by the number of the seats available in that district. So if no candidate achieves 30% of the voting division number, the seat will be assigned to a candidate listed the highest ranking. So that's the law says. So for a man like Soleh, he is ranking 7, so less likely he will be able to win the seat. So he went to Constitutional Court. But surprisingly, what he did was he was attacking different provisions, which is that there's a provision in the law which is say that every 3 candidates on the list must be a female candidate. Question is, why did he attack this provision? He argued that this provision said this means that make it easier for a woman to win a seat because a female candidate will be on the top 3. Because there's a woman in every 3 candidates, which means that in top 3 there will be 1 woman. And he said that based on this systems that if nobody fulfill the voting division number, it will be assigned to highest rank people in the highest ranking in the list. So she's most likely a woman candidate will most likely win a seat compared to a man like him who is listed in the ranking 7. So the court first say that there's nothing wrong with the female candidate provision. This is lawful. But what the court did was the court held that the provisions that require the 30% voting division number or listed in the highest ranking was unconstitutional. This is what the court, struck down. It seems, again, this is a kind of, radical decisions, because the court, struck down the law. But surprisingly, that before that, the court then ordered the General Election Commissions to assign the seat to any candidate who won the highest vote in the district. Surprisingly, Chief Justice Mahfud, he wrote an op-ed piece. This is in newspaper. He said that, well, we didn't, bring anything radical. We didn't bring any radical change in the decisions. What we did was just simply to strip out that's, two provisions in the law. This is 30% requirements and highest ranking. That's what we did. We simply did that, but we never, create any new rules. And what he said that this is, the legislature intention who said that the highest vote. Well, this is not in the court decisions, but he wrote an op-ed piece, and people began to wonder why that the Chief Justice need to do that. This is not so important, maybe, but I think this is important in the sense that this is maybe really, the court, what intended to do from the get-go. They never really, want to bring any radical change, simply to provide advisory opinion. The second case by Mahfud Court is the so-called the leftovers vote case. Let me explain by the leftover vote here. As I said, that the law required that in order to get a seat, that you need to pass the voting division number. So once the parties, meet the voting division number, it obtain a seat. The problem is, not all seats can be filled immediately, because some party will not receive enough vote to obtain a seat, or some party obtains, a seat, but they won't be able to have enough sufficient vote to obtain the second seat. And the law said there must be second round of seat allocation. The issue is here how to determine the second round of seat allocation. The General Election Commissions say that the vote who's being used to determine, to decide for a seat in the first round shall not be used again in the second round. So in other words, I think that the first round is the first vote being exhausted in the first round, and it should not be used again in the second round of election, seat allocation. But some political party challenge this law to the Supreme Court, because technically, Constitutional Court has no authority to review General Election Commission decision. The Supreme Court say no. What you should do that you can use the vote that's being used in the first round for the second round. Because of this arrangement, some party will gain more seats. Then some, small party challenge this, law to the Constitutional Court, simply ask the court really to interpret what is the meaning of the law. And the court held that the law is conditionally constitutional as long as the vote used to obtain a seat in the first round will be exhausted and could not be used again in the second round. So again, here the court come out with the conditionally constitutional, decisions. But here the court presented a crucial statement in the end of his judgment. Because as I said earlier, that the court say that decision only apply prospectively, not retroactively. But here the court, Mahfud Court, came out different. It said that although the law said the court decision can only be applied prospectively, the court held that these decisions should be applied retroactively in regard to allocation of the seats for 2009 legislative election. Although the court said there will be no any compensation or financial remedy to redress the injuries that were caused by the previous regulations. They didn't give any explanation, lengthy explanation why they that say now they should be applied prospectively, retroactively. They only say that this is necessary in order to achieve public order. Although again, that it's not clear what is meant by the public order. Then I will now to move to another case. Things that just let me explain a little bit here things that, as I said, the Chief Justice has to run re-election every, 3 years or so. In 2011, the legislature reduced it more to 2.5 years. So now the Chief Justice has to run for election every 2.5 years. Chief Justice Mahfoud decided to resign after he thinks that finished his second term of Chief Justice, and part of it he has ambitions to be a presidential candidate in 2014. So by the time I think that we have new Chief Justice, but this Chief Justice only stand for 6 months. He was removed to corruption allegations, and then just in less than a year that we have 2 new Chief Justices. So this case was decided by the Chief Justice Hamdan Zulfa. This case was general election schedule. According to the law of 42/2008 on presidential elections, a presidential election shall be nominated by a political party or coalition of political parties who hold at least 20% of seats in the House of Representatives or obtain at least 25% of popular vote in legislative election. And the law says that legislative election and presidential election must be held at least 3 months apart. So why they need to hold 3 months apart? Because that political parties cannot nominate candidate immediately until they find out the official result of legislative election. And sometimes it takes 3 months, almost 3 months for the General Election Commissions to certify the official result. And plus also things that under this condition, only big political party he can nominate the presidential candidate. That's why I said that, like the PRD, that Budi Mas Juan, because there's no way for them to nominate presidential candidate, because you need to get at least 20% seats or at least 25% of the popular vote to nominate a candidate. Interestingly, in this case, that the claimant is not any presidential candidate. The claimant is something that is political activist. First, he said that this law gives too much leverage for the political parties. It will suffer presidential systems. So now I think that president will be depends on the support of the political party in the parliament. And second, he argued that the law infringes voting rights. He referred back experience 2004. This activist, he was a doctoral candidate in Nijmegen University, Notre Dame. He had to go back to Indonesia to cast his vote on April 5th, 2004 for legislative elections. But presidential election won't take place until July 5th, 2004. By the time he already went back to Netherlands, and he said that I missed the opportunity to cast my vote, and this is why he challenged law. The court agreed with the claimant. He says this is the law is give too much leverage for president-elect, for political party over president-elect, and this is unconstitutional. And the court ruled that legislative election and presidential election should be held simultaneously. But here again, the court said decision will be applied 2019 general elections instead of 2014. So again, I think this court means that defeat is on previous ruling, which is then they go back to the previous reasoning. This only apply prospectively, retroactively. And again, I think the court did not address the injury by the claimants about his claim of his voting rights being deprived. This mostly this hypothetical case for the court, and this came out with some advisory opinion here. So in conclusion here, I think that, as I said, the court has only authority to issue advisory remedy. It can only apply prospectively most of the time. And in many instances, the court refused to invalidate statute, but rather to declare it conditionally constitutional. As I said, this is initially, the politician said the court as a joke. It's turned to be serious in some way, but still there's some limitations in which the court can only conduct abstract statutory review. And because of this limitation, in some way, the court can only perform what I call a quasi-weak form review. And this is pretty evident in the case of judicial review of electoral process in Indonesia. Thank you.
Hi, my name is Shige Matsui. Thank you very much for inviting me. My topic for my presentation is election campaign regulation and the Supreme Court of Japan. There are so many constitutional issues with respect to elections, but today I'm going to focus on the election campaign regulation in Japan. I suppose this regulation is very peculiar characteristics of the Japanese election law. I suppose this PowerPoint pictures manifest clearly shows that the pictures of the election law. You have to go through these very narrow tunnels to go to the heaven. So it is only one person who can go through these tunnels who will be elected as representatives of the members of the Diet. So the Constitution of Japan declares popular sovereignties and guarantees right to vote and protect freedom of expression. And election campaign is a core of the political expression which deserves to be protected everywhere in the world. This is the essence of the democracies. But nevertheless, the Public Office Election Act, which is the election statute in Japan, imposes very stringent restriction on election campaign, and the Supreme Court of Japan has constantly upheld all of these restrictions in the past. So this is the pictures of the election campaign in Japan. I raise these various kind of questions. Basically speaking, I'm questioning whether these the holdings could be justified and all these regulations can be upheld. And especially because the significant impact of all these regulations on election as well as politics in Japan, I guess these questions which deserved. So basically speaking, I will start with the legislature and election in Japan. Constitution of Japan 1946 declares popular sovereignties and guarantees right to vote. So the people have the inalienable right to choose their public officials and to dismiss them, and universal adult suffrage is guaranteed with regard to the election of public officials. So these are the basic provisions of the Constitution. And of course, Article 21 protects freedom of free expression as well as freedom of assembly and association. Japanese Constitution adopted the Westminster system. So the Diet is the national legislature. We do have an emperor, but the emperor is now a symbol. He doesn't have any political powers. The head of the government is a prime minister, and selection as well as appointment of the prime minister is stipulated in the text of the Constitution. So basically speaking, the emperor will appoint the prime ministers based upon the nomination by the Diet. So there is no discretion on the part of the emperors, and it is a Diet, national legislature, who will choose the prime minister. So unlike some other countries which have a president, Japanese public don't have any right to choose directly the prime minister or the head of the government. So basically speaking, the Japanese people have only a right to choose members of the Diet, the Japanese national legislatures. The Diet consists of two houses, House of Representatives, this is the lower house, and the House of Councillors, this is the upper house. The House of members of the House of Representatives is 4 years of office, but it could be dissolved by the emperor based upon the prime minister's decision, so the term of office could be shorter than 4 years. There is no system of dissolution with respect to the House of Councillors, and the term of office is 6 years, and half of the members must be chosen every 3 years. So these are the constitutional provisions. And the Constitution delegated the power to provide for election to the Diet. The Article 47 provides electoral district, method of voting, and other matters pertaining to the method of election of members of both houses shall be fixed by law. So the Diet, the national legislature, has a power to provide for the election. Currently, both members of the House of Representatives as well as House of Councillors elected by the public by the combination of two different election systems. So basically speaking, with respect to House of Representatives, it is a combination of single-member election district elections and proportional representation. So they do have, currently it's about 475 members, and 295 of them would be elected by the single-member election district, which is quite similar to the UK and United States and other Commonwealth countries. 180 would be selected by the proportional representation. So the parties will submit a list of the candidates, giving a priority to the list, and the voters have 2 votes, one for the candidate in the election district, the other one for the political parties, and the political party will have will be assigned a seat corresponding to the number of the votes they can gather during the proportional representation. And candidate listed in the list will be elected according to their priorities. So this is basically a system. The election campaign for candidate for the single, I will focus on the election campaign for candidate for the single-member election district because election system is quite different, and the election campaign is also quite different depending on the election. So basically speaking, election campaign period is basically only 12 days. So 12 days before the actual voting date, the official election will be announced, and they will accept registration of candidacies, and the candidate will be allowed to start election campaign. So no election campaign prior to this official announcement of election and registration of candidacy. So that means you are not allowed to say that I will be running for office in coming election before 12 days. And anything which might suggest that you will be willing to run for the office will be criminally punished. So this is very interesting. And there is also a very strict restriction on who can participate in election campaign and how to conduct election campaign. So this is the pictures distributed by the election public election committees. So it is a violation of the criminal the election statute to start election campaign before the start of the official announcement. So you have to start at the same time. And basically speaking, it is 12 days before the voting days. And this is the pictures of the local election commissions. So when the candidates or the supporters go to the election office, then they will provide you all kind of a display and approval sheet. So you have to display one of these at your election campaign office and also attach one of these to the election campaign card. And you have to carry some banners and flags. And these are the official documents which will be provided. And you have to show and display and use all these papers when you are conducting election campaign. So this is the pictures of the election campaign office. Basically speaking, each candidate for the members of the House of Representatives is allowed to have only one election campaign office. And there is also a restriction on how many banners or placard or posters you can carry. And so each candidate will open this kind of election campaign office. So this is a typical pictures of the inside of the election campaign office. So in many cases that they will call on the Shinto priest to wish for the win of the elections. And as you can see, there is a miniature Shinto shrine and offerings. And you can see on the left side the pictures, a Japanese Daruma doll, which is a symbol of perseverance and luck. And you can see both of the eyes are blank at the initial. And when the candidate open an election campaign office, they will write in one eye, wishing for when they win, they can fill out another eye, the accomplishment of the win. So this is a typical inside pictures of the election campaign office. So now this is a public election board. So each candidate is allowed to attach one posters in a column assigned. And this is basically the only posters the candidate is allowed to print and distribute. So basically speaking, each candidate can print and attach posters in all election public bulletin board. But other than that, you are not allowed to print and distribute or attach any kind of posters And as you can see, all these posters, usually you can see only the name and pictures and affiliated or endorsing political parties. Now, this is a public election flyers, which is compiled by each of the candidates, and the public election office will print out, and these election flyers is usually included into the newspapers and distributed to each of the houses. So these are the, basically speaking, two ways the public, the candidate can distribute information. Other than that, there is very strict limitation on what you can do. So this is the election campaign card. Each candidate is allowed to have only one election campaign card. And basically speaking, you can run this election campaign card all around your election district. There is a restriction on number of the person who can ride on this election card. And this election car can run from 8 o'clock to 8 o'clock. And there is a ban on using this election card across the hospitals and the schools. So all these kind of restrictions is in place. And basically speaking, this is announced, female announcers, the MCs, she is repeating the name of the candidate and begging for the vote. Well, repeating the name of the candidate is very important in Japan because each of the voters have to go to the polling station and write down the name of the candidate by himself or herself. So just to make sure that each of the voters correctly remembers the name of the candidate. So this is the usual tactics of the election campaigning. Well, you can have public gatherings in front of the stations and make a speech, or you can shake hand. So these are the, practically speaking, all you can do. And any other kind of election campaign method is strictly prohibited. And this is a public rally, individual rallies. So the candidate and the political party can have this kind of individual political rallies in support of the candidate. But it is only the candidate and political party which is allowed to have this kind of a rally. So independent organization would not be able to hold public debate among a candidate because it is against the law. So this is one of the very important consequences. So any kind of a benefit or money to the voters will be prohibited. And if the voters also accept or received any kind of a money or a benefit, that is also against the statute. And so this is a very strict limitation on providing benefit and monies. So this is a very important characteristic of the Japanese election campaign regulation. No door-to-door canvassing is allowed. So that is to say, you cannot knock on the doors of your friend and ask for the vote for a particular candidate. And in order to prevent circumvention of this ban on door-to-door canvassing, you are not allowed to knock on the doors of other persons to announce the political rally of the political candidate, or simply refer or mention the name of the candidate or endorsing political parties. Well, if your friend comes to your house, you can ask him or her to vote for a particular candidate. But you are not allowed to go to your friend's house and ask for a vote. Then you will be arrested and criminally prosecuted. So this is very interesting because probably in other countries, I guess door-to-door canvassing is the most practiced method or typical method of election campaign. And nevertheless, it is strictly prohibited. And the funny thing is, all these distribution of documents and the ban on display of placard or any kind of a document has been interpreted as applicable to the internet. So when the official election campaign starts, the candidates are prohibited from renewing home pages because renewing web pages is regarded as distribution of the public materials document. And so the government took a position that the candidates should not be allowed to send email or update any web pages if the election campaign started. So I guess this is quite ridiculous. No other countries, I guess, has maintained this kind of a strict ban on internet. Well, with the growing dissatisfaction, the government has now partially liberalized. So now it is free to use the website so that candidate will be allowed to renew the web pages, and the candidate will be allowed to send, in some cases, some social media communication as well as email. But still, there are strict limitations on the voters from sending email. So you're not still allowed to send email to your friends asking for a vote for a particular candidate. And email, the candidate can send email to the voters only if the voters gave a consent to receiving email in advance. So that means that all these campaign email has been regarded just like a spam mail, so that the candidate must have advanced explicit consent in order to send the email. So to that extent, that the use of the website, internet, is partially liberalized, but still there is a very strict limitation. So now this is a picture of the voting place. You have to you have to use these places to write down the name, and you have to cast the vote to the ballot box. So now this is the pictures of the typical ballot papers. So you have to write down the name of the candidate as well as political parties. Well, since most of the Japanese people are illiterate, so that there would be no controversies, but this is very interesting method. So once the ballot is cast and the polling station is closed, you can see all these ballots are calculated. So they do use special papers, where even if the voters fold the ballot, it will automatically opens when they calculate. So that is some kind of a devices to speed up the calculation. And when the candidate wins, they will say banzai, and then the head of the political party will put red roses on the list of the candidate. So this is the current Prime Minister, Mr. Abe. And they will write down the name with the other eye to the dharmas, which is appreciating the thanks of the lab, the thanksness of the contribution. So this is a typical Japanese election campaign style. And it is very strict criminal penalty against any violation, and very significant disenfranchisement for violators. So basically speaking, if you violate any of these election statutes, you will lose a right to vote as well as right to run for office for 5 years. This is very strict. And what is interesting is that the Supreme Court of Japan has constantly upheld all these ban on election campaigning in the past. Well, for example, the Japanese Supreme Court has specifically upheld the ban on election campaign prior to the registration after the official announcement, and also it upheld the ban on distribution of documents, and also it upheld the ban on door-to-door canvassing. So every restriction has been upheld by the Supreme Court of Japan. Well, basically speaking, all these judgments shares common characteristics. Basically speaking, that the Supreme Court of Japan would say that all these restrictions are just the regulation of the particular method of expression, so that it is not the restriction of the expression itself. It is just a matter of regulation of a specific method. And if we allow free election campaign, unnecessary competition will be caused, and inequalities based upon financial ability will be created, and maybe bothering to the voters and causing unfairness to the elections. So all these restrictions are held as necessary and reasonable. That is the basic reasoning of the Supreme Court of Japan. Are these restrictions justified? Well, I doubt it. I don't think any other countries in the world has adopted such very strict election campaign regulations. And these are the basic reasoning. So basically speaking, that the Japanese Supreme Court tend to believe that the election campaign must start from the same time, and each candidate must do the same. And other than that, you are not allowed to do anything other than that. Well, part of the reason for all these regulation is the financial inequalities. Well, right now, the printing out necessary minimum number of the posters and preparing for the placard, all these are public paid. And the candidate is allowed to use public facility for free of charge for several times. So most of the basic campaign method is pretty much covered by the public fund. And each of the political party will be receiving a very substantial governmental grant. So most of the public campaign is already funded by the government. And each of the candidates has a limitation on the money they can spend on public election campaign. And if you violate all these campaigns spending limitation, you could be facing a criminal penalties as well. So I guess that the basic ideas of the Japanese Supreme Court is that each candidate must compete each other equally, regardless of their financial abilities. So this must be probably the most basic reasoning of the Supreme Court of Japan. But the funny thing is that a political party can run political advertisement without any restriction, even during the time of the election campaign. So the political party can run the broadcasting or newspaper advertisement promoting their causes and their argument. But they're not allowed to specifically endorse a particular candidate. But it is free to conduct public political advertisement as free. So naturally, the LDP, the most wealthy political parties, can run many political advertisement, and most of the public small minority parties will not be able to run any political advertisement. So I guess that basic reasoning of the financial inequality argument might be, I guess, questionable in the end. And basically speaking, the Japanese Supreme Court would say that election campaign is a special kind of a speech to be distinguished from political speech, and the legislatures must impose reasonable restriction on election campaign as distinguished from political speech. But I doubt that there is no such distinction between election campaign and political speech. And the political speech, almost everybody agrees that political speech is a core of the freedom of expression, which deserves to be most rigorous protections. And it's kind of irony to say that the election campaign, which is the basic core of the political expression, can be regulated very leniently. So, and the Supreme Court of Canada, Japan is usually upholding all these campaign regulations. So I guess I'm quite doubtful whether all these regulations can be justified. And all these regulation is very much controversial because it has a very significant impact on election as well as politics in Japan. So it's only 12 days. The candidate has no sufficient time to give sufficient information, and voters will not have sufficient information to cast a vote. So I guess that these regulations have a very significant impact on voters' decision to cast a vote. So I guess that the Japanese government should better reconsider all these regulations and adopt much more free election campaign as possible. Thank you.
Good afternoon. My name is Uyang Ri, and I'm a member of the faculty at Seoul National University School of Law, teaching and researching primarily in the area of general constitutional law, and particularly issues pertaining to the system of representation and freedom of expression. And I've been working at SNU since 2004. It has been great honor and pleasure for me to be part of this project to look into the public election system and the judicial review and the constitutionality review on the laws and the process of respective jurisdictions in Asia. It has been truly fun and interesting on my part as a researcher in Korea to look into the public election system, election law, and the relevant Supreme Court and the Constitutional Court decisions in Korea in a comprehensive setting and context. And I am truly excited to learn from you all, distinguished experts in and for respective jurisdictions. So thank you all, and with special thanks to Po-Jen and the University of Hong Kong. The part I am writing is the judicial review of public elections in South Korea. As Po-Jen indicated at the beginning of today's conference earlier in the morning, my understanding is that why we are all here today is to primarily to share the penetrating purpose we pursue by this project and to try to make the structure and the composition and the style of the respective parts of the book consistent to the extent sensible. As all of us did, I prepared and submitted the draft for the South Korean part, but it is only the very first draft, and I am working even harder now on it as the semester in my home institution is over by now. So your comments on the structure, the style, the substance, simply on any aspect of the draft will be greatly helpful and much appreciated. So I prepared my PowerPoint slides loyal to this purpose of today's meeting. So it does not correspond on one-on-one basis to my draft itself, because I will cover only certain parts this afternoon of the PowerPoint slides I prepared. I will run the slides from now on, containing pertinent information beginning now while I am making some introductory remarks. So you should all effectively separate what you see on the screen and what you hear just for 5 minutes or so, and then I'm going to come back to the slides, and then we'll share the information and perspectives with you along the slides. But so the slides will be available as well if you would refer to them later to make comments on my part, because the slides I prepared will give you more of the, like groundwork frame for you to, better understand the Korean constitutional, political, and legal structure, and then so that you will better understand the, where I have come from for the perspectives and in my analysis overall on the election law and the election system and the constitutional court's decisions on such in my part and in our book. Today's presentation will show, so from now on, what you see on the screen will be slightly different, but I just wanted to show you some of the real, detailed information as to what our legislature has been doing and the Constitutional Court has been doing, how it consists, it gets constituted and whatnot. So maybe you can just go back and forth. Okay, so today's presentation will show what I have done and what I want to say and what I want to show in my part that covers the public election system, the public election law, and the Constitutional Court stances and its actual decisions since its establishment in 1988. So in South Korea, as probably all of you know, we have a separate institution of Constitutional Court, independent of and separate from the so-called the ordinary judiciary topped by the Supreme Court, of course. And the Constitutional Court stances since 1988 and its unique constitutional political history and reality since the establishment of the inaugural democratic state with Republican form of government in 1948, right after the closure of the Second World War, and the Korea's unique separation of power structure, particularly under the current constitution that came into effect in 1988, epitomizing South Korea's democratization movement initiated by the citizenry. The draft for my part has a very plain structure. The first part is the introduction. In this part, I write about how the election system and the relevant laws in South Korea have evolved as they currently exist along the following line of events. First, South Korea's unique location and positioning in light of its modern history as a democratic republic since 1948. Then, government-led economic growth and its ramifications for and ensuing characteristics in South Korea's current institution of law and the separation of power structure currently, primarily on how and why the judicial review conducted by the Constitutional Court in South Korea has elevated justification on South Korea's idiosyncratic constitutional democracy ground, specifically in the public election context. Then, two military coups d'etats in its modern history in 1961 and in 1979, and following authoritarian regimes during which the executive branch intended to and actually did dominate the legislative or lawmaking function over the nation's legislative branch itself by making use of and sometimes even manipulating unique features of South Korea's legislative process, allowing, for example, I'm going to go back to the statistics here. So this is the period I specifically refer to. By sometimes even manipulating unique features of South Korea's legislative process, allowing, for example, the executive branch to introduce a bill, as well as the members of the National Assembly themselves to National Assembly, and those standing committees within National Assembly have such concentrated lawmaking powers, while our National Assembly is a unicameral, not bicameral legislature and whatnot. So if you compare the statistics with the more recent statistics here, you can see what I say by the government's in its relationship, the executive branch's relationship to or with or even against the legislative branch, exerting its influence on lawmaking and whatnot, up until the 1980s, and like very distorted once again statistics here as well. Next, citizen-initiated democratization process, especially in the 1980s, that was materialized in the adoption of the current constitution that came into effect in February of 1988. Most symbolically introducing direct election of the nation's president and local elections for the chief executives of the local government and for the members of the local legislatures and for the proportional representation system at National Assembly level. Achievement of the relatively stable and mature democracy and rule of law in 1990s and on, and the function and the contribution of public election in this regard, both in symbolic and actual meaning. And certain modern challenges South Korea faces these days from the perspective of public election law and institutions, such as, while we all face these issues all at the same time, but also to Korea, diversification, globalization, pluralization, aging of the population, and so forth, requiring more significant role for the representation system and therefore the system design of the public election. In the main part, I try to explain history and the structure of South Korean public election law and the public election system and the actual administration of public election, some of the unique aspects and features idiosyncratic to South Korea, and the Constitutional Court decisions on corresponding aspects and features. Then in the conclusion for the part on South Korea, I offer some general analysis and make certain suggestions for legislation and constitutional courts decision making. So through several slides, I will mostly try to build and fortify our shared foundation so that we can more structurally view the South Korean case here. For your further comments later on the parts I am writing. which will at the same time more clearly show to you the grounds for the perspective I have taken in analyzing the law and the system of South Korea's public election law and the judicial review thereon. So your comments will be much appreciated. So, and I'm gonna at this point go back to the slides, and from now on, I will have to skip many of the detailed information part, but okay, so here we go once again. All right. Some of the, like historical events in South Korea's constitutional political history, establishment of the Democratic Republic right after the closure of the Second World War, Korean War, economic growth largely led and initiated by the government and its democratization process largely initiated by the citizenry, particularly 1980s and on. And it eventually led to the adoption of the current constitution that came into effect in 1988. And that's the same year when the Constitutional Court was first established in South Korea with very specific and limited jurisdictions through which most of the judicial review type constitutional adjudication reached the Constitutional Court. Okay. All right. Okay. So these are some of the main actors you will see in the scene. Where the Constitutional Court of the Republic of Korea get to review some of the constitutionality issue over some of the features at the statutory level, particularly. South Korea's National Assembly, which is the national legislature, it's a unicameral, which is very important in the South Korean political scene, not bicameral, but unicameral legislature with 16 standing committees. Committee system is very common, at least not uncommon, but it has very highly concentrated power and authority, which all began during and under the so-called authoritarian regime that following the military coup d'etats, which is important because, okay, for the sake of the justification ground, you may say, is the efficiency, expertise, and whatnot, but we have altogether only 300 representatives. Out of 300, 246 are elected single-member electoral districts, very proportionally small proportional representatives, 54 out of 300. There is a single nationwide electoral district for the election of the proportional representatives, and they can only be elected from the party list. And then, if you recall, not just the member, 10 or more members of the National Assembly, but also the executive branch can introduce a bill to National Assembly. And if you divide up, all those individual members of National Assembly may belong to up to 2 standing committees, and in actuality, everybody does. So if you do quick calculation, most of the 16 standing committees consist of 15 to 30 members there, and it's a unicameral national legislature. And if you look at the statistics currently, there are more than, the 18th National Assembly is the most recent National Assembly that has finished its 4-year term. The current sitting assembly is the 19th, and the term will go through next year. So if you look at the statistics here, within 4 years, you have to take care of this many bills. So as long, if you belong to 2 of the standing committees, there's physically no time for you to go over, other legislative bills to actually review those bills and whatnot, which has been a significant issue in South Korea. So this, but we had to do this because of the unique situation in South Korea under the authoritarian regime, because the government, the executive branch, they, okay. You look at the number here. The executive branch introduced more number of bills than the entire bills introduced by individual members of the National Assembly in this, 6-year term here. And then if you look at those bills introduced by the executive branch, most of them were legislated with no revision during the legislative process at National Assembly. So what we really tried to do during the so-called democratization period in South Korea was to largely empower the National Assembly or the legislative branch against the executive power to normalize so-called the balance, power balance between and among the so-called political branches of government. So even the ramification, influence on the election law in South Korea is that like they opened up leeways for the National Assembly members, their lawmaking, process and whatnot against the executive branch. So it's coming back now more or less. So in the eyes of the public, like legislative bills introduced by the individual members of the National Assembly, they don't really, in terms of the quality, even the government introduced bills are better in the eyes of the public and whatnot. Then you may say, okay, the Supreme Court, the Constitutional Court justices, they are not elected, they are appointed. They probably have expertise, institutional capabilities and whatnot also, once again, in the eyes of the public, opening up more space for this Constitutional Court and the Supreme Court to get in this political, very much political scene of the public elections and whatnot. Okay, so we're gonna go more to the point here. Constitutional Court of the Republic of Korea, which was established in 1988 under the current constitution, they only have 5 limited jurisdictions, and constitutionality review over the statute and the adjudication on constitutional complaint. These two are the gateways for most of the constitutionality review cases on public election issues and statutes reach the Constitutional Court. Okay, public elections, there are 4 different types: general election to constitute National Assembly, presidential election, and 2 types of local elections. But I'm going to concentrate on general elections to constitute National Assembly. They kind of like overlap quite a lot with what we have just heard from Professor Matsui. 1 person to vote, following this 2001 and 2004 Constitutional Court decisions, and then the following revision of the relevant statutes. Very strict regulation and whatnot on the election campaign activities, even at the statutory, not at the lower level, law level, but the statutory level and whatnot. All because, if you trace all the way back, we have this experience with the so-called authoritarian regime established after the military coup d'etat and whatnot. So they have this much concern for fairness and neutrality because under those authoritarian regimes, they resisted regime change, sometimes by manipulating then existing election laws and whatnot. So even the Constitutional Court today, they put weighted balance on or for the fairness and neutrality over or against the freedom in general, or particularly freedom of speech, political speech, in even public election context. So if you go to look at the idiosyncratic characteristics of South Korea's public election law, we have a blanket statute, General Consolidated Comprehensive Election Statute of the Public Election Act. Well, we have this system that's probably all familiar to you, all the constitution, statute, and executive orders and the rules and whatnot. So at the statutory level, we have this consolidated statute. mandate of the basic principles applicable to public elections at the constitutional law level, statutory level, very detailed regulations and restrictions on the election campaign activities concerning the actors who may conduct the election campaign, the timing. We also have this designated time period for public election campaign. In Japan, 12 days we all heard, and in the Korean case, 14 days, slightly longer. So I'm gonna cut off most of the details because it's almost exactly the same. The statute, not even the lower level law, the statutory provisions themselves regulate in specific numbers in centimeters and millimeters, like the size limit of the armband, shoulder band and whatnot, like how many times the candidate herself or himself may send an email, SNS expression and whatnot, even the real name verification requirement for internet service providers outside of this designated 14-day public election campaign period and whatnot. Okay, so I'm just going to go directly to the major cases of the Constitutional Court. One person, one vote. Two, one person, two votes. There was this 2001 case rendered by the Constitutional Court, and there was a following revision of the statute. Also, as to the apportionment of the electoral districts, the Constitutional Court, over time, they rendered three different decisions, 4-1. We began with 4-1. That's very lenient. 3-1, and as of last year, it's 2-1, and also it's exactly the same as the case in Japan. Requiring majority of over 50% of valid votes, the national legislature tried to introduce this, but the Supreme Court back then, prior to the establishment of the Constitutional Court, said no on the ground of free vote and election and whatnot. But when you shift the scene and go to the detailed regulation restrictions on the specific campaign activities, the Constitutional Court, just like the stance the Supreme Court of Japan has taken, they have been very lenient. They have been very passive. Designation of election campaign period, not unconstitutional. Ban on election campaign activities on labor unions, other NGOs, not unconstitutional. Mandatory real name verification during the election period, not unconstitutional. Mandatory deposit of trust money, not unconstitutional, and whatnot. So if you look at all those case laws established by the Constitutional Court of Korea, very proactive, very active constitutionality review on basic principles of public election, but passive stance on the statutory provisions regulating and restricting election campaign activities in detail as to who, when, and how to conduct campaign activities. So we need definitely consistency with freedom of expression law towards more freedom and flexibility from government regulations and restrictions, because it might even adversely affect the entire established judicial review system, and particularly the established standard of review so far established by the Constitutional Court. So that's one thing. And particularly now that South Korea's democracy and rule of law have relatively matured and stabilized. Number two, Constitutional Court's application of review standard in reviewing matters concerning public election, particularly detailed specific regulations on who, when, and how election campaign activities may be conducted. Once again, there is a skewed application of constitutionality review standard in light of the entire structure of the constitutionality review system in South Korea. So, in both directions, we have lots to do in the future. So thank you so much.
Okay. Good afternoon, everybody. I would like to introduce myself first. I'm an illegally. I'm come from Taiwan, and right now I'm a postdoctoral fellow at National Taiwan University College of Law. So thank you for having me today, and it's my great honor to be with you today. So as the slide shows, actually today the paper I present has two authors. My co-author, Professor Wenchen Zhang, actually is not here today, and she just went to New York for ICON conference. So today I will take this responsibility to present this paper, and I hope I can do it very well. Okay. So so now I'm going to tell the Taiwan story, and I will actually our paper will just focus on presidential elections disputes, and we would like to address how the courts deal with such presidential election disputes, and we also would like to discuss what the strategies the court used to respond such disputes. Okay. And today, my presentation actually has three parts. The first one, I will briefly discuss how the direct presidential elections was adopted, and I also will discuss the powers of the president. And the second part, I will discuss the litigations relating to presidential elections since 1996. And then the final part, I will discuss the strategies. Okay. So now, so the first part, I will just give you a very brief background of our presidential elections. I think most of you may have known Taiwan has direct presidential elections, and actually this direct presidential election was held in 1996, and since then we already have 5 presidential elections, and in those elections we actually find there are numerous legal and political charges between presidential campaigns and the candidates. So there are lots of litigations actually have been brought to the court for the judicial resolutions. Okay. So that's the questions we would like to address. Then in our paper we just systematically to examine those judicial decisions, and we also try to discuss the strategies. Okay. As I say before, we have found there are many legal and political charges between the presidential campaigns and the candidates. And so the first question is, well, why there are so many disputes happening before during presidential elections? Actually, these questions can be answered from the presidential elections and the presidential powers. I think more of you have known actually Taiwan undertook several rounds of constitutional reforms in the course of the democratizations. And one main reform is to open election for the legislators and the presidencies. So actually, during in this process, there are several rounds of negotiations between the political parties. So finally, after 2 rounds of, actually, the 4 Fraser direct elections for presidency was complete after 2 rounds of constitutional revisions in 1992 and 1994. And in this process, we also find the powers of presidents were expanded and consolidated through the revisions. Here, I can give you some examples. Now, in the two constitutional revisions, actually the president actually owns more substantial powers. For example, president can have a power to appoint a prime minister, and the president also has a power to dissolve the legislative yuan upon the request of the executive yuan. So the president's powers was expanded and consolidated in the process of the constitutional revisions. So right now, our president actually has become the most powerful government institutions. So that's why the competitions between competition over the elections between the parties will become so intensified. Okay, and here I would we also would like to show, because the presidency has become the most powerful government institution, so the confrontations between the among parties has increasingly intensified. And as I said before, until now we already have 5 presidential elections since 1996. And in our papers, we just we have already described how the intensified elections become, and actually we divided the 5 presidential elections into 2 contexts. The first context is a democratic transition. We find actually the first and the second presidential elections were held in such context. And after 2000, now the Taiwan's politics become quite divided and intensified. So the other 3 elections actually were held in the context of a divided politics. Okay. Due to the interest of time, I will not go to the detailed parts of each presidential elections. Now I just show you this table. Just show you the candidates and the turnout of 5 presidential elections. So as I say, after the first 2 elections were just held in the context of the transition to democracy, and the other 3 elections actually were held in the context of the divided politics. Yeah. So, as I said before, now we find the presidential elections increasingly become intensified. So there are many litigations actually enter to the court, and we actually do lots of research, and we find those cases from our court database, and those cases actually can be divided into 4 categories. Those categories are shown in slides. The first lawsuit is about the legitimacy of elections and the elected status of the candidate who won the elections. And the second litigations is about the politically charged civil and criminal defamations. And the third litigations is about the legality of a presidential elections regulation. And besides those judicial decisions, we also include the decision of the prosecutors. I think this category is quite distinctive, especially when we compare other countries' experience. Okay. So I will introduce the first category. The first category is related to the legitimacy of elections and the elected office. Here, the good example or the obvious example is the disputes in 2004 presidential elections. I think most of you may have known there were some disputes around these elections. And the first one is about the legality of the referendum. Actually, because before the 2004 presidential elections, actually our legislative yuan in 2003 actually passed the Referendum Act. And this Referendum Act provides president has power to initiate a referendum. So at that time, our former president, Chen Shui-bian, just decided to initiate one referendum. And this referendum was actually finally decided to be held with the presidential election. But this decision was criticized by our opposition party, that is the Pen Blue campaign. Okay. So these are the first disputes. And the second dispute is about the gun shooting incident before the election day. You may have heard in that election, actually before the election days, the gunshot incidents just occurred. And but the elections actually was decided to sustain. So after polls, the president Chen Shui-bian just won this election with a very narrow margin victory. But our opposition party, actually is a Pen Blue campaign, just refused to accept this election result. So, and they also launched quite a large-scale protest to the president. So finally, the Pen Blue campaign just decide to bring the lawsuit to the court. And then actually this Pen Blue campaign brought 2 lawsuits to our high court. Okay. The first one is to challenge the legitimacy of an election. And then the second one is to question the status of the candidates. They are our president Chen Shui-bian, okay, who just won the elections. And so before the court, there were some issues. For example, the issues is about the legality of a referendum and the decisions of the central. Because I say, the elections actually was decided to sustain. So the second issues is the Pembroke campaign challenge why our central election commissions did not suspend the elections at such situation. And then the other issues is also about the way the voters cast the ballots, because our government decide referendums will be held with the presidential elections. So the Pembroke campaign just challenged the way to receive the referendum ballot and the presidential election ballot actually violate the principle of the secret ballot. Okay. But after 1 year revealing, actually our court delivers to final judgments. And in 2 lawsuits, actually the court ruled the elections was legitimate. So the court just dismissed the 2 lawsuits finally. And then the second category is about the litigation regarding presidential election regulations. Just like other countries, we also have 1 central election commissions, which was established under Executive Yuan in 1980s. Actually, the main function of this commission is to hold and supervise all levels of elections. And our legislative yuan also made many electoral legislations that empower our election commission to supervise the election. So, but since the first presidential elections, actually they were several lawsuits which has been brought to the court. Those lawsuits actually was challenged the decision of the election commission. For example, in 2000 presidential elections, our central commissions actually punished 1 presidential candidate who just refused to declare his property when he registered the election. And this candidate actually just refused to accept these decisions, and he just brought the case to the court. And then the court actually finally sustained the decision of the election commission. Okay. And then the third category is about the civil and the criminal defamation lawsuits. I think this category is also very unique if we compare to other countries' experience. We find in 5 presidential elections, numerous defamations charged was made by the presidential candidates and relatives and others. And here we just divided those lawsuits into 2 categories. The first category is about the civil and the criminal is about the criminal defamation lawsuit, and the second one is about the civil and a civil defamation lawsuit. Due to the interest of time, I just show now we actually divided those especially civil defamation lawsuits into 5 categories. You can see the first category is about the lawsuits of the candidate against others, and the second one is the lawsuits of the relatives of the candidate against the members of another presidential candidate presidential campaign. The third one is the lawsuits of the relatives of the candidates against others. The fourth is the lawsuits of the members of the presidential campaign against others. And the final one is the lawsuits of others against others. So actually in our paper, we just made some tables, and those tables has detailed information about those litigations. And then the final one is about prosecution decisions. It's very interesting. When we observe our presidential elections, we find the prosecutor, especially public prosecutor, actually are often that requires to initiate investigations to the disputes between the campaigns and the candidates. Here we just mentioned 3 very well-known cases. Okay. So the final part is I will discuss how the courts deal with developer strategies to those litigations. I think the first strategy is the judicial deference strategies, and this actually, if we look at, we can tackle the 2004 presidential election litigation as examples. Actually, the decision of the court actually demonstrate they defer the results of elections when the elections was held in a fair and impartial matters. If we look at the lawsuit, the judgments about the 2004 presidential election, we can find actually court in those decisions use procedure standards to carefully examine the elements of the issues of the elections. Those elements or the issues actually has a close relationship with the fairness and the impartiality of the election. So we find actually the court when the court carefully revealing the issues, we find the court actually the final decision is the court decide to maintain the election, because the court has very clearly his decisions will influence the subsequent of the politics. Okay. And the second strategy is also the judicial deference, but in this we find, especially when we look at about the decision about the litigation, about the decision of the election commissions, we find actually the court just endorse the decision of the election commissions, and actually so that's we can say the court choose a judicial deference policy, a strategy, and then we argue this strategy actually has huge beneficiaries. That means this strategy can maintain the integrity of elections and also secure the authority of election commissions. Okay. Can we give me 1 minute? Okay. And then the third strategy is actually the court, especially in the criminal defamations litigations, we find that the court will use a judicial detachment policy, which means when we look at the criminal defamation cases, we find the timing for the court to make a decision and the standard of the court used demonstrate the court will not never made the decisions when the elections still proceeds. The court usually will render their decisions after the elections. So this strategy can help the court to detach themselves from the contentious elections. And the standards of the court is also demonstrate the same features. Okay. And the final strategy here is actually the court will, especially when the court deal with civil defamation cases, they will use the judicial intervention strategy to protect the reputation rights of candidates. And in most civil defamation cases, we find the courts usually will use a text-based approach to try to develop a certain standards to find a balance between the freedom of speech and the protection of the individual reputations. So, here we argue the court through such interpretation approach substantially protect the reputation of the parties. So that's my presentation. I will stop here. Thank you.
Well, thanks very much to all of the presenters. Thank you. It is a great privilege to be a part of this conference with such an illustrious group of scholars and to comment on this provocative set of papers. I must say that I've learned a great deal from each of them and that I have no doubt that when this volume is published, it's going to be very helpful to people, not only in understanding judicial review of elections in Asia, but in informing continuing debates over judicial review around the world, including in my own country, the United States. So I want to give special thanks again, as everyone has done, to Po Jin for bringing us all together and for bringing this volume together. I've been asked to comment on these drafts and the presentations you've just heard with reference to the U.S. experience with judicial review. It's a happy responsibility because I found the papers both instructive and indeed inspiring, and there's a lot to say. Virtually everything in these papers resonates, at least to some extent, with the United States' very long experience with judicial review of the democratic process going back really a century if you include seminal First Amendment cases. Not all of that experience, as I'll suggest, has been positive. Let me start with a point on which I think in fact, all 5 of the papers, one of the authors could not be with us today, from this panel agree, that review of election rules and practices by an independent judiciary is necessary, indeed vital, to a well-functioning democracy. This, I think, is a premise of all of the papers. An independent tribunal is essential to check the power of those in power, to ensure that they don't misuse that power to rig the rules of the game, to freeze out others from power while locking themselves in, to prevent entrenchment, as Jen mentioned earlier, a central problem that to some degree all of these papers, in fact I think all of the papers today, are wrestling with. Now this is an experience with which we have long and largely unhappy experience in the US. The most egregious example in our history is the long-standing disenfranchisement of African Americans. The end of our Civil War in 1865 brought the end of slavery and new amendments to our Constitution, including the 14th Amendment that guarantees equal protection of laws for all and is now understood as the source of the fundamental right to vote, as well as the 15th Amendment, which expressly prohibited race discrimination in voting. Yet notwithstanding these guarantees in the text of our Constitution, white Democrats in the South systematically suppressed black voting, starting in the 1870s and proceeding through the late 20th century. The lesson here is that words on the page, be they equal protection, the right to vote, freedom of speech, that's one thing. The reality on the ground is quite another. Now, the Supreme Court, our Supreme Court in the US, originally in the early 20th century abdicated its responsibility in a famous or infamous case called Giles versus Harris, basically said this isn't our problem. This is a problem for the political branches of government, Congress in particular, to fix. Eventually, however, the Supreme Court stepped in, stopping white primaries and eventually in the 1960s articulating decisions guaranteeing one person, one vote, striking down poll taxes, one of the devices used to keep blacks from voting, and striking down gerrymandering, at least in some contexts. I hasten to emphasize, however, that while courts are important, they can't do it all alone. In the end, going back to the US experience, it was Congress's enactment of the Voting Rights Act of 1965, as well as the Supreme Court's enforcement of that act and the Constitution, that ended the systematic disenfranchisement of African Americans. So, two points that I really want to emphasize. First, the necessity of an independent judiciary. Second, that an independent judiciary isn't sufficient to ensure a well-functioning democracy. It also takes cooperation with political actors and the people itself. So one of the big questions of institutional design implicit in all of these papers is how judicial review can function so as to induce cooperation, willing or unwilling, from political actors rather than resistance. There are, in the papers that I'm commenting on, two major recurrent themes. There's a lot else going on, but what I want to focus on in my comments is two big recurrent themes. One is the question of what I'll refer to as active or passive review. Term that's sometimes used in the United States and elsewhere is, do we want activist courts or do we want judicial restraint? I don't like that formulation as much because I think it sort of rigs the analysis because restraint sounds like a good thing when it's not always a good thing. So active or passive review. When should courts assert themselves? When should they be aggressive? When should they exercise more deference to political actors like legislators or more independent actors like independent electoral commissions? The second big theme of these papers, robust public debate. Democracy depends not only on how things are run on election day, but on what happens before and after Election Day. on their being, as the great U.S. Supreme Court Justice William Brennan wrote in New York Times versus Sullivan, a public debate that is wide open, robust, and uninhibited. What can courts do to promote that kind of debate? Now, in sort of setting up our discussion that will follow, I want to encourage the same thing here. I want to encourage a debate that is wide open, robust, and uninhibited. I'm going to give a few comments on each of the papers with a question for each of the panelists that I asked them to address in the order that they spoke. And after that, my goal is to keep things hopping. I'll give the panelists an opportunity to ask questions of each other, and then I want to open up the floor and give all of us a chance to ask our questions and make our comments. I want to keep this forum as interactive as possible by giving you all plenty of time for your own thoughts. So first on Indonesia. Stefanos's paper nicely discusses how a constitutional court with some very severe structural limitations has acted. On the question of justiciability, on what sorts of cases the court can decide, one note I'd make is that it's almost the mirror image of the U.S. system. In the U.S., courts can only decide concrete disputes, not hypothetical ones. You describe a system which is almost the reverse, where it's only the abstract or hypothetical future prospective issues that courts can describe. Your paper focuses on some very interesting, to me, techniques that the court has adopted given its structural limitations. First, declaring a rule or practice to be conditionally constitutional, as, for example, it did in the political crime case, and more recently, declaring a law or practice to be conditionally unconstitutional, as it did in the Armed Forces voting rights case. This is somewhat analogous to U.S. courts' practice of declaring rules unconstitutional as applied in certain circumstances, as opposed to unconstitutional on their face, while suggesting that they're okay as applied to other circumstances. Now, you characterize this in your paper as a weak form of judicial review. My question for you is whether this is the best that this particular court can do given the structure that it's been given. This is a court that, at least from reading your paper, seems not immune from retaliation, from political struggle, as evidenced by the high turnover of Chief Justices. So is this the best that we can expect from a court that's structured in this way, or are there other things that this court, given those structural limitations, might do? On Japan, Shigenori emphasizes an idea that he expressly at the beginning of his paper draws from U.S. law, this idea that public debate on matters of elections and politics ought to be wide open, robust, and uninhibited. So as a Japanese American, I must say that I find his description of Japan's system absolutely fascinating, made even better by the images that he shared with us. He describes a set of laws in Japan that muzzles public debate through onerous restrictions on speech, strict limits on the timing of election speech, prohibitions on candidates paying campaign staff, only one campaign office, just one car, how literature can be distributed, strict limits on broadcast media, in fact, no commercials, and restrictions on false speech. Now, in our conversation during lunch, he said to me, well, I think most of those would be unconstitutional in the U.S. My answer is no, you're wrong. All of them would be unconstitutional under the First Amendment as our Supreme Court has interpreted it. Now, I hasten to add that if Japan is at one end of the spectrum, the restrictive end, when it comes to campaign speech, the U.S. is at the polar extreme, and I think too often has gone too far in that extreme, especially in failing to recognize other values, most notably equality, and the danger that the wealthy and powerful voices will drown out all the rest. So on Japan, he's very critical. He was much more polite in his presentation, but in his paper he's a little bit more pointed, saying it makes it impossible to engage in a free election campaign, the Japanese restrictions, that is, and I tend to agree. So my question is, what's the backstory here? Why has Japan's Supreme Court been so restrained, or to be more blunt, so timid in its exercise of judicial review? I think I have a sense of the answer, but I'd love to hear you respond. On Korea, I'm going to focus on a particular aspect of Woo Young's paper. She mentions in the paper a concern that runs in sort of the opposite direction from the concern regarding Japan, at least a perceived concern regarding the judicialization of politics, that the court has been too intrusive. Now, you note in the paper that the Constitutional Court has been proactive in its exercise of judicial review generally. More than 500 decisions holding statutes unconstitutional in the past quarter century. That's quite a lot by any measure. In the realm of democracy, two kinds of cases that you discuss. It's been quite active in its review. I'm gleaning from your paper. Its review of barriers to participation and representation. You mentioned, for example, the apportionment cases where it's gone from 4-1 in 1995 to a rule of 2-1 in 2014. Also, the court struck down a ban on probationers voting in 2014. On the other hand, when it comes to restrictions on campaign activity, campaign speech, the court has been, you note, quite passive. Like Japan, it has tolerated many restrictions on speech that would be manifestly unconstitutional under the U.S. First Amendment, such as regulations on the campaign period and broadcasts, even text messages. So this is another example where I think the United States is kind of the mirror image. At least in recent years, our court has been, in my view, unduly passive when it comes to restrictions on participation and representation. For example, refusing to get involved in cases involving partisan gerrymandering, also refusing to intervene in constitutional cases challenging very restrictive voter ID rules, requiring ID that many voters in the United States, especially poor people and minorities, do not have. The court has stayed out of these cases, or at least has declined to strike them down. On the other hand, our Supreme Court has been very active, overly aggressive, I would say, in striking down campaign finance laws, including not only laws preventing corporate spending in Citizens United, but even public funding laws in Arizona. All of this on free speech grounds, refusing to recognize other important values like the risk that wealthy and powerful interests will enjoy undue access and influence. So the paper suggests that the Korean Constitutional Court's refusal to intervene with respect to campaign speech has actually helped incumbents in the party in power. This, I would argue, this is where we really most need judicial review. So the question, a similar one to the one that I asked with respect to Japan, why has the Constitutional Court been so active in this area? So passive in this area when it's so active in others? Is it a structural problem? Is it the court's lack of independence and fear of retaliation by political actors? Is it that the court's membership is ideologically aligned with those in power? So what is it? What, again, is the backstory here? Turning to Taiwan, we see both of these major themes in evidence in your paper. Both this theme of active versus passive review and the question of robust public debate. The paper argues that judicial deference to an independent election commission is a good thing. And I think there's a lot to this argument, which bears a resemblance to the exchange I had with Surya earlier. I've made a similar argument in the context of US elections as well. The more independent an election management body is from partisan politics, well, the more we can trust its decision-making, so the less searching judicial review has to be. On the other hand, the less independent such a body is from partisan politics, the less we can trust it, and the more searching judicial review ought to be. I want to turn to your discussion of defamation, which I found to be fascinating. The story you tell is that the Constitutional Court has narrowly construed criminal defamation laws. This is an example of what we in the United States would call constitutional avoidance, reading laws narrowly in order to avoid a conflict with constitutional rights. So in Taiwan, reasonable grounds for making a statement can excuse even a false statement, and the court will also consider the public interest. When we turn to civil defamation, however, you paint a very different picture. The courts have been much more sympathetic to, or at least tolerant of, civil defamation cases. Your paper and your presentation point to several examples of such judgments being sustained by the courts. So here's my question, and it draws directly from New York Times versus Sullivan, with which I began. Can't civil liability and defamation lawsuits chill speech regarding politics as much, or at least almost as much, as criminal liability? The prospect of a substantial civil judgment may well cause people to be chilled in expressing their views for fears that it will bankrupt them financially and ultimately may impoverish political discourse, suppressing speech necessary for a wide open, robust, and uninhibited public debate. Why isn't the answer, the best answer, to speech we don't like, that's damaging to the reputation of public figures like candidates for office, speech in the other direction? So I'm at my time. I will stop there and invite you each to first respond to my question in the order of your presentation.
Thank you, Dan, for your comments. And I'd like to address some questions. First, about justiciability. Yes, indeed, this is a kind of mirror image of the U.S. Justiciability rules, especially on the issue of standings. Mm-hmm. Because in the case of Indonesia, that standing rule is very, very loose, and you don't really, have established, injury. You can show a little bit, but the court don't really, it doesn't really matter. Yeah. Because the basic rule is that you can come to the court to bring a public interest. Just the things that we don't need. The court doesn't have to go like the case of Pakistan with a suo motu case, actions, because in Indonesia the court just hoping that there's some public NGO or so some citizens who can challenge the case before the court. Let me cite the case of armed forces case, which is I did not have time to explain in my presentations, just for the audience. So because military in the past has controlled the country for 32 years under military dictatorship. So after the fall of military governments, they banned the military to cast the vote in general elections. Because in the past, they play important role and they have voting bloc in the parliament. So they say that military cannot participate in politics any longer. But the law says that it won't be applied in 2000, for general election. Question is, how about 2009? Right? So there's two activists who went to the court and challenged the law, and they don't have any interest whatsoever. But they simply say that, yeah, this is means that we think it's unconstitutional, and we need to ask the court to to clarify this. And as you say, that the court say this is conditionally unconstitutional, as long as it doesn't include 2009 general election. Yeah, so this is that the illustration indeed. I think that this can mirror in the U.S. Whether this is the best the court can do in Indonesia, I think I ties it with your that first remarks about active or passive review. I will say that what happened in Indonesia is kind of passive aggressive in some way, because I think that here the court tends to kind of issue that kind of decision is I think in between, but in some way I think that try to come out with something in the middle. Yeah, tend to be passive with, but quite aggressive in some way. And looking at the political condition in Indonesia, that's yeah, maybe this is the best they can do so far. I think that as you point out that yeah, the court is not really immune from attack from different branches of government, because this is yeah, the cost was just only about more than 10 years old, and established 2003, and still very fragile in some way, and they didn't get any sufficient support from the beginning from the any branches of the government, financial support and stuff. So this is kind of a weak in some way institutionally, but under the leadership of the first Chief Justice, I think that he tried to flex the muscle a little bit on his limitations, and they came out with this. And I'm interested also in this case because basically what their technique about conditionally constitutional is not really brilliant either, because they just copy basically what system in South Korea, and as Muyong I think that presented in your chart, there's a conditional in certain contexts, right? So basically they just borrow the technique and then use a different package. So that's I think what the case in Indonesia. How long it will last, I don't know. I think that, but there's a trend is increasing more and more now. I think they use this the decision as conditionally constitutional or conditionally unconstitutional, especially after the removal of Chief Justice in 2008. So the second court, the Mahfud, then he used more of this technique, and it might be the case still in the future, as the things that. The court is kind of getting weaker, especially after the removal of the third Chief Justice to the corruption allegation. So that's
Thank you. Generally speaking, the Supreme Court of Japan is very passive, and with respect to freedom of expressions, it has never, ever invalidated any statute restricting freedom of expression in Japan. And the Supreme Court of Japan also adopted very passive attitude with respect to many of the election matters. But recently, the Supreme Court of Japan has struck down governmental failure to allow citizens living abroad to participate in elections as unconstitutional. So to that extent that there is nothing that will prevent the Supreme Court of Japan to actively reviews and strike down legislation if the court finds it unreasonable. So I have to speculate on why the Japanese Supreme Court has been so reluctant to engage in any active review on any of these restrictions on election campaign. Well, my thought is that during the history of the post-war, especially during the Cold War, there has been very political volatile issues between the leading parties and opposition parties. The government has been occupied by the conservative liberal democratic parties, which is supported by the very huge political donation by big companies. which is aspired for the maintenance of the liberal democracies. On the other hand, there are many kind of opposition parties, including a communist party as well as socialist parties. These parties are backed by the unions, and most of the activist union member is public employees. So these, between the LDP and the socialist opposition parties, there are certain very controversial matters, including the ban on door-to-door canvassing, as well as a criminal ban on political activity by public employees, and also a comprehensive ban on right to engage in strike by public employees. So these are some of the very politically controversial issues. In the 1960s, there once was a time that the Supreme Court of Japan came to adopt somewhat critical attitude against the comprehensive ban on right to strike by public employees. The Supreme Court of Japan came to view that depending on the specific type of the public employees, the comprehensive ban may not be reasonable. But the backlash from the LDP's politicians are quite severe. They criticize the Supreme Court of Japan as politically biased, and they threatened to engage their appointment power to steer the Supreme Court of Japan back to a conservative stances. Against this background, the Supreme Court of Japan backed off. So that the Supreme Court of Japan changed their attitude and came to defer to the judgment. And I guess that's the one incident taught a very significant lesson for the Japanese Supreme Court. And ever since then, the Japanese Supreme Court is pretty much restrictive and reluctant to engage in active reviews unless they are pretty much satisfied that their judgment will be acceptable, politically speaking, especially backed by the public opinions. So I guess that maybe in the future, the Supreme Court of Japan might be willing to overturn these precedents and came to apply much more active reviews. But right now, I guess, still not the time for the Supreme Court. And that is my speculations.
Yes.
Yeah.
Once bitten, twice shy.
In South Korean case, very importantly due to South Korea's experience with the past authoritarian governments, like topped by the then incumbent presidents who became civilian only after the success of the military coups and whatnot. So under which the legislative body constituted by the general election got largely stifled by the executive branch. So after, after we went through the so-called democratization movements, they meant to make sure many things would then now empowered legislative branch pertaining to the public election in general to be subjected to the statutes. Not like executive orders, not like rules that could be issued by other independent constitutional institutions of the government. So by the statute that could be only made and revised by the National Assembly. So that is in part why our constitutional court in South Korea, have had so many cases of constitutionality review over the statute. So all those strict, detailed, specific regulations pertaining to campaign, specific election campaign activities, they are by the statutory provisions and not like lower level laws. Once again, even the apportionment, redistricting, that authority is given to this commission that is instituted within National Assembly at whatnot, largely on the statutory grounds once again. So as to the more general question of yours given to all of us here, those, maybe it's like not like established insider perspective in the general constitutional law. But if you think about this area of where specifically those, non-political branch, of the governments may step in, I have always thought about like, perhaps there's like quite a lot of overlap or, many aspects will coincide, at least if we think about this direct democracy as opposed to representative democracy, unless even if a jurisdiction or a state does not adopt full-scale direct democracy measure, especially in lawmaking, like voter initiatives and whatnot. If you select some of the areas of lawmaking, then just, in a very limited sense and to a limited extent introduce direct democracy measure, maybe the first candidate for such areas is where those incumbent members belonging to political branches of government, there's conflict of interest concern and whatnot. And I believe when we talk about the public election law and the system, this is where so many of conflicts of interest issues, rise against incumbent members of the politics and whatnot. So, and in this background, South Korea's constitutional court, because it is an independent constitutional institution separate from the ordinary judicial branch with very limited and visible and intentionally politically charged jurisdictions, such cases. And at least currently, South Korea has legal and institutional grounds for, close citizen monitoring, NGO, active NGO monitoring and whatnot, just general freedom of expression law and institutions to monitor the activities of the constitutional court, because once again it has very visible and limited jurisdictions, and the public election laws are very much argued and decided through such constitutional adjudication mechanisms within the constitutional court. Because of the same reason, the Constitutional Court of South Korea has had this so-called healthy competition, institutional level competition with and against the Supreme Court. They are very much aware of their significant role in the nation's democratization process, because that is the very symbolic creation of the institution only under the current constitution that came into effect in 1988. So, just for like an example goes, we don't have this mandatory representation by the attorney in South Korea overall, but only at the Constitutional Court you have to be represented and whatnot. So this is, at least I believe, this is one of the examples of the healthy institutional competition between the Constitutional Court and the Supreme Court. They know that they have to be good, right? Especially when it has to do with democracy and whatnot. So, like collision between political powers, there's incumbency issues, for example, especially when there is minority protection issue, equality issues, then at least the Constitutional Court of South Korea in the Korean context may be very vocal. As to your more specific question, so as to the general rules and principles of public election, South Korea's Constitutional Court has been very active, proactive, very vocal, because once again they have taken their role in the nation's democratization process very seriously. They know that they have to bring this very good performance report towards the public, very small like 500 cases. They deal with 1,000 cases per year recently, whereas the Supreme Court is dealing with 35,000 cases, quite a lot. They are overloaded, but it's relatively small, and they are closely looking at Constitutional Court because, once again, they are, with those jurisdictions over the cases that are fully politically charged. But when it comes to specific regulations on campaign activities, number one reason goes, once again, the past experience with the authoritarian regime, because unfair election activities under such regimes led to civil uprisings, and once again, eventually the second military coup d'etat and whatnot. But number two, so I will have to do more like detailed empirical research in this regard, but I do believe that the Constitutional Court in South Korea, due to aging of the population, it might sound like jumping into a different direction, but since South Korea has been traditionally very homogeneous, and now out of sudden we are experiencing pluralization ethnically and ethnic diversification due to labor immigration and whatnot, value pluralization and whatnot, plus this aging of population, very low birth rate and whatnot, everything combined. Online representation of values and predictions and as you say, robust public debates even, that didn't, at the end of the day of the public election, many things had been discussed online through SNS and whatnot, but those generations, actively expressing their ideas through SNS or other online medias, it's limited. So that didn't, end up representing the, the corresponding results at the general election and whatnot. So in this, everything combined, the Constitutional Court in this regard wants to be very careful. So they don't want to risk, they don't want to, step out and being very proactive and whatnot, and then oh, what if, maybe it's not the right direction. Number two, we have been very little regulation on campaign financing so far. So at least to me, it seems like the Constitutional Court in South Korea wants to divert the direction of their attention to campaign financing restriction from nitty-gritty restrictions, because that could be revised one day altogether by the revision by the National Assembly, and which is quite near, it seems like. So everything combined, they are.
Thank you. Billy.
So thank you, Professor. Thank you for your comment and questions. And I would like to respond to your comment first. You just yes. I think the most the most unique feature, about our judicial strategy to presidential disputes is just like you say, just like our papers mentions. Our court actually will defer the decision of the election commissions. Why we would like to emphasize this part? Because according to our administrative litigation law, the disputes about the decision of the election commissions usually will goes to administrative court. Compared to other, if we would look at the disputes about decision of election commissions, just like I say, the court will endorse the decision. But if we why we say this is very unique, because if we compare the decisions of our other decisions of our administrative court, usually especially in recent years, our administrative court usually will revoke of the decision of the administrative agency, especially when the court deal with the case about the environmental law. The court usually will, to reverse the decisions. But we find but when we look at the election context, we find the court actually has a different position. Yeah, so that's the first part I would like to respond. And regarding to your questions, actually, the court in criminal defamation cases, the standard the court used actually comes from the United States. Yeah, and here I would like to explain. Actually, from our research, we find the parties usually, especially candidates, usually they will brought the defamation cases to different court, not different court. It's a different branch. It's a civil bench within the court, and the other one is a criminal bench within the court. But actually, the parties they can brought the case to different bench, but the results of the lawsuits is quite different. Why I say this? From our research, we find the party usually in criminal defamations cases, usually they will lost the lawsuits, and but on the other side, we find the parties in civil defamation lawsuits usually they will won the litigations, and we find the court actually in criminal defamation cases. It seems the court, when they use the standard from United States, the court usually will emphasize the democratic function of speech. Although the court did not distinguish speech in the election context and the speech in the non-election election context, the court, in most cases, when the court emphasizes the democratic function of speech, that means the comments or the speech, especially those comments are made in fair manner, then such comments or speech should be tolerated. But in the civil defamation cases, we just from our research, we find the court just in very few cases will use the standards. The standards as a civil defamation case. Actually, in civil defamation cases, the court will develop their own some standards from the existing laws. Just like our papers mentions, actually the courts just in the civil defamation cases, they will develop some criteria, and those criteria will emphasize the reputation, the importance of reputation, and the court will say reputations is based upon the social evaluation. I think it's very unique. I think it's very unique criteria, and the court also will emphasize. need to find. Yeah. So my point is the court in different defamations cases developed or adopted different standards.
Yeah.
So that's why in our cases it shows it has different results. Yeah. So that's my response.
Thank you very much. Po Jen, and then we'll open it up.
Yes, hi. Sorry, because I'm writing an overview for all the chapters. So if I may, I wanted to clarify some questions so that I don't get your jurisdictions wrong. For Japan, can I just clarify? You mentioned a Supreme Court of Japan case whereby voting rights were accorded to which new group of voters? You said there was a Supreme Court of Japan decision whereby the court struck down a law which restricted voting from a certain group. Which group?
The Japanese citizens have a right to vote, but if they are living abroad, they don't have any local residence in Japan.
Abroad. Okay.
So they will not be able to participate in the election.
And the law was struck down.
So yeah, that's right. The Japanese Supreme Court has struck down the failures of the government to include provision which will enable every Japanese citizen living abroad to participate in the election.
Aside from their law, has there been any other electoral laws that have been struck down by the Supreme Court?
No, this will be the first time.
Oh, wow. Awesome. And I have a question for Woo Yong, if I may, which is, when the courts reduce the population ratio from 4:1 to 3:1 to 2:1, I was just wondering, the pre-existing ratio, was that an administrative decision or was that imposed by statute? So in essence, is it constitutional review or is it purely an administrative review?
Okay, so it was, struck down, or like, okay, so the pre-existing, it's not specifically statutory provision. It's more like a table attached in the attachment form to a specific statutory provision of this general election law of the Public Election Act. So at least it is part of the statutory scheme. Therefore, the Constitutional Court could exercise its jurisdiction. So 4:1, 3:1, 2:1, there was no, express language anywhere of the public election law, right? So it should be, up to the limit of 4:1. There's no such language. Even still, there's no such statutory language of 2:1 is the limit here. But if you look at the schedule or the table that is in the attachment form to that specific statutory provision having to do with, equal votes and whatnot, and the apportionment of the electoral district that should take, consideration of, the population discrepancy, urban, rural characteristics and whatnot. There's whole elements listed in the statutory provision. Okay. So,
just echoing, I think, Dan's question earlier, which I thought was a fantastic question. Why would the courts be willing to be so abrasive in dealing with this systemic inequality, but not be as willing to deal with something as trivial as campaign periods, which seems less controversial?
But, okay, so when it comes to the specific regulations and restrictions on specific activities of the campaign activity, we have had actual experience in reality. Those specific provisions were actually manipulated in the past. So they want to be more careful. Okay, so they can't really give up statutory restriction or restriction at the statutory level.
But isn't this statutory to the fault? I mean, the population ratio, isn't it a statute?
The population ratio was at least not manipulated by the authoritarian regime, right? And then, it was like more understanding towards the general public because, it was more rural back then, getting very, but urbanized nationwide. And it's a small country, South Korea, right?
Okay. So the ratio was not an entrenchment policy or tool by the government?
No. But if you look at the actual, districting, the discrepancy between the most populated and the least populated districts was 4-1, 3-1, and 2-1, right? And the language of the Constitutional Court and such decisions was like, okay, if it's over 2-1, that would be excessive. So those were the languages used by the Constitution.
Thank you so much.
So let me suggest, because we've got only a few minutes left, only about 7 or 8 minutes left, why don't we collect questions and comments and then invite panelists to respond?
Senior lawyer who is one of the founding members of the Workers' Party, which is actually a Marxist party, not a big party in electoral stakes, but it's a registered political party. And he brought that case in that capacity on the explicit premise of equality, which is what you're citing as the Japanese Supreme Court is relying on as well, which is based on this equalize what they specifically asked for was regulations as well regarding banners and posters, regulations and offices, for this I mean, not what they specifically asked for was for the court to effectively help those it seems like a huge contribution there
Great.
All fascinating. Two things occurred. One, I didn't suggest meeting with this explanation, but I do think I will bundle into a general description of culture a past history prior to democracy as informing it. And I think on some level, the exchange you guys just had about the difference between the expectation of door-to-door canvassing explains it. I just wonder to what extent any of the cultural explanation, and by that I mean, again, pre-democracy experiences, enter the discourse that the courts use in explaining why they come to the decisions that they come to. Because these patterns are quite fascinating and tell an interesting story. I just wonder how upfront they are with it. And then, I guess, second, does it matter then that there are really heavily contested elections that inform all of these questions? Because, I mean, I love the fact that I now have a better sense of these papers, because I was focusing so much on these, that the pattern seems to be fitting throughout, that courts are very interested in being active on access questions, but on structure questions, not so much. And that's certainly consistent with the American story. I just wonder, does that have anything to do you think, with the contested nature of politics, or is it something else entirely?
So any more questions or comments? Okay. Any of you who want to respond to Kareem?
Right. Well, at least since 1980s, in the South Korean case, all those public elections pretty much were heavily contested, but the law as a whole just requires simple relative majority. There's no, like something like French national, presidential election, unless you get, preponderance, like over 50%. It's like very typically there are more than 5 or even up to 10 candidates in a single out of any of 246 electoral districts. So if you just require simple majority, it could be elected with 20% out of whatever. So in that background, it will be more important to what seems to be fair and neutral regulation, I guess.
So any final comments? We have a couple minutes left from panel.
I can just make a comment which I found interesting. I guess when I was hearing the papers about Korea, Indonesia, there's this constitutional in certain context variation. I guess in common law courts in Hong Kong and the UK and presumably in Canada, we have what you call the reading down powers, where courts will read down a legislation to make it compatible. So by reading it down, it only applies in a certain context. So I guess that could be a comparable power between our jurisdictions. And there's this thing that I think Korea was talking about, is Taiwan, where the constitution, I think it's Korea, where it's not unconstitutional, but it does not conform to the constitution, and it's for the National Assembly to fix it within a time frame. I think that sounds a lot to me like the suspension order in Canada, South Africa, and in Hong Kong, whereby the law is declared unconstitutional, but it's preserved until Parliament enacts a law that satisfies the constitutional mandates. So in a way, I guess we are all trying to solve problems in similar ways.
In the South Korean case, we don't have any statutory ground for that, but the court has been doing that.
Yeah, and that was purely created by the judges in Canada and in Hong Kong too. Nothing in the Constitution says so, but it was just created.
So let me conclude by asking us to thank all of the panelists and authors for not only informing but engaging in a wide open, robust, and public debate.
And as organizer, once again, thank you all for coming for this conference. Thank you for speakers for flying all the way, some from Pakistan, the United States, from London. And for those of us who are interested in this project, the book will be published hopefully sometime in June 2016, so look out for it. Thank you very much.
Great.